All right, let's talk together about preservation and issues of preservation. Remember, we've divided the process into preservation. You know that litigation is reasonably anticipated or it's been commenced, and so you want to preserve documents first, and then we're going to talk about production and production down the road. So let's talk about some of the key areas that you need to cover with your client when you're dealing with preservation issues. In order to be able to be clear with the client, you may have to deliver a very bad message that in fact litigation is on the way and you need to stop doing what you're doing. And when the message is bad, the delivery has to be good. You've got to get the attention of the right person. You've got to go up high enough and you've got to get their attention to make sure that if what they do is they continue to destroy documents or delete files or carry on with business with usual, what they're subject to is a Arthur Anderson accusation that they were destroying documents when they knew that litigation was pending. So when you're communicating to the client about the seriousness of this, it's important that your communication really be good, because obviously the message is, at least initially, is bad. Let me just also suggest to you to be paranoid, to not take assurances from the client that in fact, oh, we've had this before, you know, don't need to worry about it. These aren't bad players, these are good people, I'm sure they're not doing anything wrong. That what you've got to do is you've got to be careful and be paranoid, because the facts are usually worse than they appear in the first instance. Doesn't mean you don't have a case, doesn't mean that the other side isn't also doing some bad things, but recognize to be paranoid, a little paranoid is important at the beginning of the preservation issues. Stay organized. Just working hard is not going to be enough here. You want to keep yourself organized as you're starting to think about what your tasks are. And so let's organize together what the preservation basics are. You're first going to try to put in place what's called a litigation hold. Second, you're going to walk through with the client the mechanics of preservation. You're going to make sure that what you say is going to be put in place is in fact going to be put in place. Then you're going to look at some narrowing tools for how it is that you're going to narrow the preservation down to what is reasonable and at least disruptive for the business. If you need to hire a vendor, I'll give you some tips and suggestions as to what to think about when you're hiring a vendor to help you in this process. And then what are the immediate next steps after the litigation hold is put in place? Finally, dealing with the infirmities in the client's document retention policy, because folks, they're bound to be. That what you have are document retention policies that we'll talk about that have been downloaded from the internet based on some IT person's trying to find a policy because they've been ordered to find one and have one. And the chances are that the IT policy with regard to the retention of documents is not being implemented. And that's just a given in most of the litigation that you'll have. So let's talk about the objectives of the hold. First, it's important to realize that your objectives are to suspend the destruction so you cannot be accused of being sued and then continuing to destroy documents. And so what you have to do is think of overwriting of data and backup media. If that's being overwritten, you've got a problem. And if you've got reformatting of disk drives, if there's something that's going on where there's a reformat or a new migration, that's got to stop. Converting to file formats that eliminate metadata is also something to be worried about and concerned about. Of course, you don't want to be involved in using some kind of scrub software that is destroying or erasing data. You got to be careful that equipment is not being disposed of, that you just happen to have a recycling process in place and you're cycling out old computers and replacing them with new computers in the middle of a litigation. And finally, what you have to do is you've got to fix responsibility for the implementation of the hold on somebody in the organization that has the juice to be able to make sure that it happens. The problem here is it's not just enough to say we need to do this, but you've got in fact to take reasonable steps to ensure that the client has done this in order to avoid problems down the road. Now, you also want to provide for monitoring of the hold, where you are involved in monitoring what it is that's going on, whether or not the archive system that's being created or whether the system that's being created to be able to, a server that's going to be used for the data to be stored in the preservation process, whether or not in fact it's being done. Now, the best case message has these components to it. What you're trying to indicate to the chief executive officer of this company is that destruction and migration must stop. Right now, everything, everywhere. Now, obviously, the resistance from a client who, especially as a repeat player, is going to be significant. What do you mean, everything? We've got divisions all over the world. What do you mean, everywhere? We can't shut down the business and preserve and keep this going. It's going to be extremely expensive. Why do we need to do this? Well, because right now in an early discovery process, you don't know where the bad data is or where the bad information or bad evidence is, if there is any. And what you don't want to do is you don't want to be cavalier about your taking reasonable steps to put the litigation hold in place. Recognize that you may already, with a repeat player, have an understanding of what it is that they're going to do with the key players or the key data or the key information and where you're going to preserve it and where you're going to make sure. But if that's not in place, first what you have to do is to be very broad and very inclusive, and you have to stop the destruction. No more backup recyclings, no more just kind of business as usual with the emails, where in fact it's going to be deleted every 2 weeks or 3 weeks, because obviously this has got to stop, and it's all email and everybody right now. Now this is temporary, and you should describe this as being a very temporary situation, but we've got to have it implemented, we've got to have it in place. I'm intending to go and speak to opposing counsel, and we're going to try to negotiate a joint protective order where we can come off from this in some kind of speed in the next 3 days or 4 days. But in the meantime, for the next number of days until you're told otherwise, you've got to go ahead and put a litigation hold on the destruction of all the data. Now, the destruction of the migration can start up again only under clear rules, with clear directions and a clear understanding. And that's not a decision that can just be taken on by the IT person himself or herself. That you really need to be clear that you want a broad hold, you want everything stopped, and you're going to work back from that only upon some very clear directions that are coming from you, the lawyer. And when you have protections in place, so that what you have is you have a way of, again, taking a snapshot or a mirror image of what it is that you've got on your system, and you've got that now stored and set aside and separated. And in situations where what you have is you don't have an ongoing problem, or people that in a sense could still create some kinds of evidence that could affect the litigation, keeping it going, then what you have is the primarily concern is to preserve what's happened in the past. And obviously, if protections are in place for that then, and it's clear, then you can release them from this litigation hold. And I would suggest that what you do is you set up a written permission process that's required before somebody takes on the task of going ahead and starting to go back to business as usual on their own. Now let me talk about and address this conversation with the client, its form, the timing, and the addressees of the communication. So you want to make sure that in writing you communicate clearly to the client what it is that you want in the way of the preservation issues. It's got to be in hard copy, and you want to make sure that what you have is you've indicated as clearly as you can what the litigation hold is for. You want the signature from the chief executive officer or from the person with authority, and the language that you pick should track the language of the law. The language is litigation is reasonably anticipated, or litigation has been commenced, and therefore you must stop the destruction of the documents. You want to obviously address this to the IT department head and to the known key players. So what you're doing is you're making sure that the key players in this litigation have notice that they cannot destroy their files or back them up, and it has to be in as official format as they can so they realize the seriousness of taking matters into their own hands. The supervisors of IT departments and the key players need also to get this information. So it's not just enough to get to the key players, but send that notice to their supervisors also. No deletions of files. Finally, the functional heads of the major departments also need to be aware of what it is that's going on. And so you go up that corporate chain to the people that they report to and the folks that those supervisors report to make sure everybody is on notice that you've got yourself a problem. Now, who are the targets for the preservation? Obviously, the targets of the preservation, or what are the targets, are business-maintained electronic storage. You want to make sure that you take a look at the current employee-maintained electronic storage. So who are the current employees that maintain that storage? Number 3, you do also have to be aware that there may be ex-employees who also have data in their equipment and in their files that in fact could be subject to the preservation orders. Now, the business-maintained storage, you've got to talk about the network servers, the file servers, the email servers, the database servers, to make sure that these are all thought about when you're thinking about the recycling and destruction and deletion processes, and ask questions of the IT people about the web servers and the file transfer servers and the voicemail servers that may be involved. Now, network logs, data hosted remotely, and backup data storage all needs to be thought of when you're thinking about the preservation of data. Finally, archive data storage needs to be preserved so that there isn't some cleaning out that's going on in the archive data that also would subject you to a destruction claim. Now, I've boxed for you here, the suggestion that what you do of these network servers is to make a mirror image of these. In the appropriate situation, you want to capture it and take a snapshot of it to be able to to preserve it and know where you stand and get that done. In addition, what you're looking for is, with backup data storage and archive data storage, you want to just make sure that whatever destruction may be in place is suspended, and that make sure that in fact they know that whatever backup data storage recycling process that they're using is something that is stopped. The employee maintained storage, remember, you're thinking about personal computers the employees have, their desktops at work, their laptops, if they've got PCs at home. Personal internet files, you've got a concern about emails and blogs. These are areas that are in play. Web pages and podcasts. Personal backups that they may have, where they are backing up to CDs, have to be thought of. External disk drives that they may have that they take to different places. Online storage with application service providers like the accountants and things like that, that those folks have to be contacted to make sure that they don't destroy things. So you've got CDs, DVDs, floppy disks, zip disks, and key disks. Those things that you carry around, flash drives in your pocket, those also have to be thought of to make sure destruction doesn't go on. And then, of course, you've got to think about other storage, cell phones and PDAs and iPods now, and ask to make sure that, in fact, data that's on those systems is not destroyed. So, with the personal computers, you make a mirror image. With the personal internet files and personal backups, ask about them and the business content of these. And make sure that, in fact, if there's any business that's being conducted on these things, that, in fact, there isn't destruction that's going to go on. Now, the problems in preserving the employee-controlled storage are obviously privacy, employee relations, employee efforts to defeat the preservation, personal encryption, personal use of permanent erase software, personal methods for hiding files. These are all things to worry about. Let me just say a quick word here. You know, it turns out that a very high percentage of white males, could be all males, as far as I know, but I know the study in terms of white males have pornography on their systems. It's just common that, in fact, that's an issue that you've got, and when you're told you've got to preserve data, the immediate issues are well, am I going to be found out for the pornography? And so the temptation is for people to run in and then delete these kinds of files. Please remember that what you're trying to do is to say you will ensure the privacy of these materials. That is very unlikely that the other side will be interested in that, because they're not interested in turning over the pornography for their own employees. But what you do need to do is you need to preserve it all, and preserve it right now to start with, and to try to address these privacy concerns directly with the employees as opposed to leaving it to them is one of the important tasks of implementing the preservation holds. With regard to ex-employees, are there any ex-employees that are relevant to the case? Does the document retention policy provide for ex-employees? These are key questions for you to ask to determine whether or not there's some preservation issues that are involved here. And how are the ex-employee files retrieved when the employee leaves, and where are they stored? You want to ask about that. And what happens to the computer equipment used by the ex-employee? That these are issues that will likely come up in the discovery if the key employee is not taken care of. Now let's talk about some things that you can think about quite quickly to try to narrow the scope of the preservation hold, to try to get it in a manageable system without shutting down the business. Well, first of all, it can be that the client decides what it is that they're going to allow happen, and the client can try to say that, you know, I'm only going to do this, that other stuff is too disruptive and too costly. Recognize that, in fact, in many cases, the costs of the mass preservation are things that the company is already tasked to do as it's trying to deal with business reasons for maintaining its data and making sure that it's preserved. And so often when you really address with a chief executive officer really how much more expensive it's going to be if they just don't recycle the backup tapes, or if they contact the internet service provider that is providing them with backup systems and say you're going to have to preserve this for a period of time, that the costs do not turn out to be that threatening. Obviously, other kinds of personal data and other kinds of situations with personal employees, you've got a problem. And obviously, a client may have some employee relationship issues that they're really reticent to address, and they have to obviously weigh in and make some of these calls. The opponent could, though, and this is where we would suggest that you might get up with the opponent very quickly and get the opponent to agree to narrow. And when you obviously have got the opponent that is facing a similar e-discovery search on their side, it may be that what you can do is quite quickly negotiate on preservation issues and come off from the mass holds. Obviously, what you can do if there is difficulty in either of these cases is to go very quickly to the court and enlist the court's help in narrowing the preservation issues. Now, one way to think about it then is to think about these issues in narrowing your preservation. What are the key players in the litigation? What are the affected units in the litigation? What's the date range that's likely going to be involved? What search terms might we be able to come up with and agree to that will allow us to have some comfort that we're getting access to the information that we need to get access to? If you can negotiate over these three things, and also if you potentially could negotiate sampling to determine whether or not the data is relevant, you may be able to very quickly agree to narrow the preservation issues to relevant data. Now, it may be that this task is appearing to you to be quite overwhelming. I mean, how do I preserve this data when I don't know what it really even means to take a mirror image of a server? How do I talk about creating a server where you're going to transfer the data from the business servers into this other server? How do I do that and ensure that in the process the native file formats are not, in fact, affected? How is that transfer going to be done? And I may be way in over my head when I start to ask some of these questions. And so what you may do is to think about going to a vendor who presumably is going to help you or assist you in this preservation task. Let me suggest to you that as you're thinking about the vendor, it's important for you to have, and I'll bet you your IT people will be able to provide this to you very quickly, a map of the client's record architecture as to where it is that things are stored. And IT people love these maps. It helps them to be able to manage their data and to be able to deal with the different kinds of data that they have. And it's very easy for you to be given, as a preliminary matter, a map of the architecture of what the data is in the company. Understanding the data that is the metadata in the client's system is also important. What kinds of metadata the client itself finds to be useful and searchable and usable, and how that affects the software that they have, and when this software systems that create the metadata were employed and updated, etc., is important for you to be able to understand what the vendor's task is going to be. Determining when routine operations destroy files and having a conversation with the vendor to help you do that is going to be important. And frankly, the vendor can help you map the architecture of the data systems, and they can provide you with a good understanding of what's going on. The vendor can also document retention practices. They can interview the various people involved and figure out what is it that is exactly being done. The vendor can make mirror image files and do that without destroying the document. And finally, what they can do is they can also help you or assist you in preparing a statement to the court, helping to prepare the pre-request production of documents by helping you think about what the costs are going to be able to deliver various kinds of data from various kinds of data retrieval systems. So they are very helpful for you in being able to give you a cost of what's going to be involved once the production starts to come up in the process. So what steps should you take after the litigation hold has been put in place? Well, first you want to locate all applicable rules on e-discovery in your jurisdiction, federal, state, and local, to find out what the requirements are in terms of what it is that needs to be provided to the other side and what needs to be provided immediately. Whether there are any standing orders by the judges in this case, likely to be in this case, about how they want to handle the e-discovery issues. And then you want to get up with the opposing side very quickly and to negotiate preservation with the opponent. What you're looking to do is to prepare for a presentation to the court where you are offering in a good faith way to try to preserve what needs to be preserved, but at the same time to limit the preservation, to be able to limit the business disruption that can otherwise take place. And then you want to gather the electronic materials for that pre-request and the automatic production request to be able to make sure that you are able to turn over to the other side what is automatically required to be turned over. Things like a map of the architecture of the IT system, the names of the IT people, and the information the other side's got a right to immediately in order to be able to understand what the e-discovery task is. You're also required to turn over to the other side what your document retention policy is, and you're going to find very quickly that the document retention policy is often not what is followed by the company in the practice of the actual IT people. You want to investigate all possible problems and infirmities with the document retention policy early so that you can confess the failures early, as opposed to getting caught having not followed the document retention policies. You want to make sure you found out what the policies are and whether they're being followed so you can confess your faults and failures right up front. You want to disclose the policy document to the other side under the Rule 26 pre-request production. You want to disclose any of the infirmities that are in existence to the other side at a very early point. And finally, be paranoid. The facts are usually worse than they seem. Remember when we talked about before in the Morgan Stanley case that people will say that documents are not available where they may be in a back closet, or they may think that that data has been destroyed when it hasn't been destroyed, or you may think that there's no way that that employee would mess with that data when in fact they have messed with the data. And the problem is that forensic folks can find that out. They can find out the timing of a scrub software being used, or when files were deleted and by whom. And so what you have is you've got to be paranoid and recognize that it's likely to be the case that the facts are worse than what they seem. So when you're thinking about your task and you're thinking about preservation, You remember, you want to start with a very broad preservation as much as you can, and then work off from that when you get to the client and the opposing counsel and to the court in order to be able to come away from that. And what you're doing is you're trying to show your good faith, demonstrate your good faith, do your own homework so that you can present a good faith picture of a client who is trying the best they can to comply with discovery and avoid the spoliation issues that are likely to be raised if you don't take that approach. Thank you.